Hello all, hope you're well. Today's date is the 29th of May 2025 and nothing in this video is to be construed as legal advice, as it certainly is not. If you would like to contact me, then feel free to email me at fraudunravelsall@mail.com. And please like the video if you think it has value, and feel free to subscribe if you fancy seeing more videos from this channel. So, for educational purposes, I worked with Lawkeeper and Cross-Examiner AI to formulate 3 or 4 questions to ask the directors of companies such as Haste Ltd, Richburns Ltd, Seeka Ltd, and Churchill Recovery Solutions Ltd. Companies that appear to be committing perjury and fraud on a daily basis, with what appears to be unbridled assistance from court and legal staff when it comes to unlawfully applying for entry warrants regarding utility matters. It would appear that this unlawful and unconscionable money-making scheme has been going on for many years, with oaths being broken left, right and centre, criminal complicity seemingly desensitised due to regularity, and public officials failing to speak out due to apparently being utterly spineless and void of morality, like low-grade members of Parliament, worse than useless to we the people. So for educational purposes, enjoy the questions Lawkeeper and Cross-Examiner audited and finalised. It only takes a few people to stand up and fight back appropriately with the light of truth and the rule of law, and this dark practice of these companies and courts, or to be more accurate, the people trying to hide behind a false sense of security and immunity they believe these companies and courts will afford them forever, and this shocking abuse of process, fraud and breach of trust against the people will end. Never give up, folks. This is all happening for a reason. Nothing can stop what is coming. Let's be the change we want to see, and not bystanders who fail in their obligation to hold public officials, crown servants, and bad actors to account. I will also be doing a similar educational video very soon with a few suggested questions that could be directed at the CEOs of so-called energy suppliers such as Octopus, and also an educational video on questions for the court staff, particularly the managers, clerks and legal advisors who have full responsibility for the shenanigans happening in Magistrates' Court all over England and Wales. Finally, I will leave a link in the description box below that explains civil fraud and the tort of deception, because for those that have already been harmed by these dark practices, there is remedy. Stay tuned. See you soon, guys and girls. So here are the questions. Questions with strategic commentary for Richburns Ltd, Haste Ltd, Churchill Recovery Solutions, Seeka Ltd, and other similar companies. So question 1. Are you a statutory operator or a direct employee of a statutory operator licensed under the Electricity Act 1989 or Gas Act 1986, specifically for the purposes of exercising powers of entry under Schedule 6 or Schedule 2B, respectively? If so, please provide material proof, including either your operator license or a copy of the statutory delegation document issued by the licensed operator explicitly naming you or your organization as authorized to exercise such powers. Why? This is a powerful question. This question targets the legal gateway to enforcement, statutory authority. Only licensed energy suppliers or their actual employees can lawfully exercise powers of entry under the Electricity or Gas Acts. Contractors like Richburns are neither. By demanding material proof of license or explicit statutory delegation, you force them to admit they have no lawful standing and are acting either under false pretense or fraudulent delegation. If they cannot provide this proof, any attempt to enter your home or apply for a warrant is unlawful and potentially criminal. Question 2. Have you at any point applied, or do you intend to apply, for a warrant of entry under the above legislation in your own name rather than in the name of a statutory operator? If such an application has already been made, please confirm the date, the court to which it was submitted, and provide a copy of the application and all supporting documents. If no application has yet been made, please confirm whether you believe you hold lawful authority to do so, and identify the statutory basis on which you would rely. Why, this is a powerful question. This exposes a widespread legal abuse. Contractors unlawfully applying for warrants in their own name. Only statutory operators can make such applications. If Richburns has already done so, they may be guilty of perjury, misrepresentation, or fraud on the court. If they have not yet done so, this question forces them to admit they have no statutory footing to proceed. It creates a paper trail of accountability and puts them on notice of personal liability. Question 3. Are you engaged in any capacity, directly or indirectly, in the recovery of a financial debt from the resident in question? If so, please disclose the precise legal basis for this activity and provide a copy of the written contract, instruction, or delegation that authorizes you to undertake such action. Why this is a powerful question. This goes straight to the true motive. Richburns and others may often claim to act for safety reasons, but are in fact enforcing alleged debts. If they are acting as a debt collector or bailiff type agent, they require a lawful basis for enforcement, not just an internal instruction. This question forces them to come clean about their real purpose and to reveal if they are abusing safety powers to enforce payment without court process. Question 4. If the purpose of your intended visit is solely related to safety, please identify the specific legislative provision under which such a visit is mandated and provide a copy of the relevant statutory notice or safety obligation issued to the resident, as required under the Gas Safety Installation and Use Regulations 1998, the Electricity Safety, Quality and Continuity Regulations 2002, or any other applicable safety regulation. Why this is a powerful question. This dismantles the safety excuse. Real safety inspections require a legislative mandate, proper notice to the occupier, documented safety concerns. If they can't cite a statutory duty, produce a formal safety notice, or prove compliance with the law, their visit is not about safety, it is about coercion under false pretenses. Misusing safety laws for financial purposes may constitute unlawful entry, harassment, or fraud. These 4 questions, if calmly and lawfully asserted, can collapse an unlawful enforcement attempt before it begins. They put the burden of proof where it belongs, on the party asserting authority. And if answered falsely or ignored, they may become evidence of misconduct. See you soon, guys and girls.